Guys. Hey, everybody. Live on YouTube now. What's going on? Live on TikTok, too. Little Friday afternoon update about the YSL Young Thug trial. I streamed the status conference this morning. It was really interesting to see the judge in action. And, just kind of when I was looking on the internets last night, I was kind of thinking of the scenario of what if a judge dies in the middle of a trial, as Young Thug's lawyer, Brian Steele, would say, God forbid, or if there was a health scare or something and a judge had to leave the case, like what happens then? And when I Googled it, California has a rule that just bakes it in that it can continue, a trial can continue with another judge. So the Judge Whitaker's approach this morning, I mean, it was obvious from the get-go, like right when she started talking, that she's not just automatically declaring a mistrial. Like she's still going to hear the mistrial motions, but she is like plowing forward. She was talking about, she was talking about, we don't want to waste the jury's time. Let's get back on track, that kind of thing. So from the get-go, the important dates are July 23rd, which is Tuesday. By the end of Tuesday, they need to file all their motions. We've already got the motion for bail from Marquavius Huey. And of course, the Harvey rule, named for attorney Bruce Harvey, is still in effect, whereas all the defendants join on their motions unless they specifically opt out. But I would expect to see some more bail motions, maybe just because people want to make their own argument, maybe. But I think we will see probably another substantial mistrial motion, because Keratin Matthews does ask for mistrial in his bail motion for Marquavius Huey, but he doesn't really get into the argument. So I think definitely by end of Tuesday, we're going to be seeing some more motions on that. And the judge gave prosecutors until next Friday, end of July 26th to respond. So motions filed July 23rd. I guess the prosecutors could file a motion. I'm not really sure what they're looking to do, but I think it's going to be all defense motions on Tuesday, and then prosecutors on the 26th. And then that gives her a few days to read them. And then they are back in court on July 30th. And it's 8:45 a.m., which I was saying in the chat this morning, like as atrocious as Judge Glanville's time management skills were and all his comfort breaks, them never starting on time, it was personally convenient for me living in Los Angeles and having, all these other cases to cover. Because I think that this judge is definitely going to be starting on time. I mean, Glanville, I don't think I'd ever heard an 8:45 start time from him, but I'd heard he'd said 9 a.m. sometimes, and it was always like 9:30, maybe 10 probably. But I think she's going to be starting right at 8:45, which for me is 5:45 in the morning. So that's going to be a bit of adjustment. But that definitely looks like the biggest change is she's going to be running a tighter ship, because it was, and I think that's better for everybody, because the trial or the case is already way too big, but to have that coupled with a judge like Glanville, who just had terrible time management skills, it was like, okay, this is a disaster. I mean, that was a big reason the trial was like just dragging on and taking so long. So we'll see that. We've also got the motion that was filed this morning from Brian Steele and Keith Adams. Maybe it was last night, but they've filed something asking for Deputy DA Love and Hylton to be recused from the case because of their involvement in the ex parte. And they're saying that they're now witnesses in that, and et cetera, need to be called. It also says Glanville's now a witness. So that is going to need to be dealt with by, on the 30th, I guess, when they get in, they're going to be dealing with all those motions. So again, let me pull it up here. This is for the YouTube crowd. But again, along with the bail motion for Marquavius Huey, we've got the motion to disqualify DA Love and DA Simone Hylton related to their involvement in that June 10th ex parte meeting. And this was filed by Jeffrey Williams, Young Thug's lawyers, Brian Steele, and Keith Adams today. And it's asking that they both be kicked off the case because it also mentions Judge Glanville because of their communications with Kenneth Copeland during a critical stage in the trial. And this is, of course, they even say the now infamous June 10th, 2024 ex parte. And they actually mention Love's involvement in her communications with Archillian Bennett, if anyone remembers that from months ago now. But A. Bennett had text message exchanged with DA Love that came out in trial. So they're wanting, they mentioned that too as the reason that she could be a witness. So they filed that. Yeah, here's the second page here, but that hasn't been dealt with. But one issue is it's going to be interesting to see what the judge actually wants to revisit, if she's willing to revisit any rulings. The defendants were not in court today, so she wasn't supposed to make any substantive findings. So she couldn't just say blanket, I'm not going to re-entertain any rulings, because that would be like making a substantive ruling. But she did say she doesn't want to necessarily look back at everything, but she did leave the door open for reconsidering some rulings. But I don't think we're going to be seeing too much of that. The big thing, and Max Shard brought this up, was they want her to go back and redecide all of Woody's interrogations, because remember, Judge Glanville, that's where we last left off, is Judge Glanville was going over the 17 hours of police interviews and then the jail calls too, and kind of refereeing the fights and deciding what was going to be shown. And, the prosecution and defense had their own objections. So Max Shard asked that they go back and redo those decisions, because those decisions were made after Judge Glanville's recusal motions were in. So under Georgia law, decisions that he made after that are supposed to be rewound. So that seems like something they probably have a chance of getting her to redo. But also, man, there were so many different decisions involved in that it'll be real interesting, and it won't be easy to do. But to see if she does go back and redo all that stuff, how much of it ends up in the defense's favor again. Because it's hard to say how much it was, but I just remember watching it that anecdotally there were some wins for the defense in there. I mean, there were some wins for the prosecution too, but it'll be interesting to see if she does go back and redo those, if it ends up being more in the defense's favor or more in the prosecution's favor. It's hard to say. But she was talking to Bruce Harvey. He was talking about bringing up a new motion regarding the ex parte and just stuff related to that. And one kind of warning sign is she didn't make a huge substantive ruling right there, because she can't, because the defendants aren't there. But she was talking about how she's not convinced that she should be entertaining more motions about that ex parte. And one problem with the motion to recuse the DAs is it describes that ex parte as wholly inappropriate, which, who knows, this judge might even read that and completely freaking agree. I mean, she could read that the transcript herself and be like, wow, this has so many issues in it. But the fact is, another judge who's untouched in this whole thing, Judge Krause, has already ruled that the ex parte really wasn't an issue, at least in terms of the recusal. So it'll be interesting to see whether Judge Whitaker feels like that's already a decided issue, or if she can somehow get back on go back on that. Somebody said Steele just filed a new motion. Let's see if we can bring it up. But the biggest changes are she's definitely going to be streamlining this whole thing. And the outfit thing, I can understand the no food in court, but it was a little alarming how, I mean, she probably went to the deputies or something who were doing this trial and asked just, what's going on, et cetera. I doubt the deputies just went to her, but she banned food in court, no eating in court, and no headphones for the defendants. And she's cutting back on the number of outfits that they can wear. Let me see if I can pull up a clip on that. I posted that clip earlier. I just realized gotta do a couple things here. Again, the next day in court is July 30th. So that's Tuesday, July 30th. She's going to be back in court. But
my fabulous litigation manager.
Here we go. Let me turn that down a little bit.
And let's make sure that these are really kind of insignificant, but I'm going to go ahead while we've got some time and bring them up. Food in court. Everybody can have water whenever they want to. The attorneys can have, whatever drink they want to, as long as you're not klutzy like me and don't spill it all over everything. I guess if you do, that'll be your problem. If we are working through lunch and the jury's out and we're working and y'all are here and the clients are here, that's okay. But snacking while trial's going on, we're not going to be doing that, okay? So if we are working through lunch, if we are working late and it's dinner time, it will be okay to the attorneys or the defendants have food. Not while somebody's on the stand testifying, okay? We're not at a movie. We're not going to be eating popcorn.
We're not at a movie.
Hopefully that'll be all I have to say about that. Apparently, one of the first things that I don't know how many different deputies told me was the clothing for the clients has gotten a little out of hand in terms of how much they all have now. I don't know, but y'all need to maybe get together and let's exchange most of that. And sure, they can have new outfits for court, but it sounds like they're like full wardrobes full of clothing for some of these defendants. And that's just a lot for the deputies to have to keep up with. So how about if y'all check in and maybe through Miss Rosser, y'all all know Miss Rosser, I think she's not even here today. Yes, she is over there. Miss Rosser, my fabulous litigation manager. And let's make sure that it gets whittled down to a manageable amount of clothing, like there are only going to be 5 days in each week. So even if they had a different outfit every day, that would only be 5 outfits. Okay. We shouldn't have 20 different outfits for anybody. So y'all need to clear out apparently the closet. So now I've done that for the deputies. They'll be more happy. Okay, next topic. Minimizing disruptions in court. I don't exactly know what that means yet, but let's try to conduct court in a way that minimizes disruptions. And we'll just leave it at that for now. There was an issue about apparently, and I'm not even sure if I understand exactly what has gone on with this, but the defendants listening through earpods to things on laptops while court is going on. And I'm not sure I understand why that's happening. And that raises some security issues with our security staff, with the sheriff's office. So can somebody kind of explain to me what that's about and why that's necessary? And if nobody wants to, then we'll just do away with it.
I laughed out loud at that. And this excuse Bruce gives is not going to fly.
All right. Well, we won't be bored from here on out. So then if that's the only reason for it, I want to be moving forward efficiently and expeditiously. So let's just plan to not have that happen anymore. And if there arises some new reason for it, then we can address it again anew. Okay? Yes, sir.
There are times where
Keratin Matthews makes the case for headphones here. Somebody asked if I think they were better off with Glanville. And I mean, it's way too early to tell. And right now I think no, because I mean, Glanville had so many issues. I mean, this trial was never going to freaking end. Things had just kind of spiraled. He seemed in way over his head handling a complex trial. And the biggest warning sign was just the time management and stuff. So just in terms of time management, I think they're better off. But I don't think this stuff is like too huge of a warning sign. Although the wardrobe thing, the no eating in court seems kind of a given. Like, I mean, Glanville was pretty relaxed with that. He was one of the biggest eaters in court. I mean, he was always up there like chomping on stuff and everything. But and the no headphones, I mean, when the deputies are kind of crying security concern on that, it's like, okay, that's kind of understandable. But the wardrobe thing is kind of just blatantly like the deputies were just like, hey, these guys were tired of their drip, because the idea that it's like that big of an issue for them. Like, so it's like, so if they get fewer outfits, are they going to move it to another room in the jail area? And then they're going to be able to use the previous area for, more stuff. Like, is it really that big of a deal? And they make it sound like, oh, the deputies are having to spend all this time like rooting through all this stuff. It's like, oh, fucking bullshit. No, they're not, but I think because like if she had targeted specific things that they're wearing, like stuff that said certain logos or something, then maybe it could be a First Amendment issue. But I do think she's probably within her right to like limit the number of outfits. But it just seems like, she kind of just got up there first off and just like read this wish list from the sheriff's deputies and implemented it. It was like everything they weren't able to get Glanville to do. But I mean, the no eating is understandable. The starting on time, it's like, oh, God forbid you do that. But I don't know. I mean, to call it like this huge warning sign and stuff, who knows? We'll see what happens. But I'm not sure. I just from the tone of this and stuff, it's like she does not want to call a mistrial. She, this is a big career thing for her. She's she's going to take the reins on this and show up Glanville and just how much better she is at handling trials. But I go back to what Max Shard was talking about in our interview, where we were just talking about, like, is it actually in the defendant's best interest to start over? We're going to have mistrial motions. And actually, I was going to bring up that new filing from Steele. But if they don't start over and it's just this new judge, and the way she's going, if she starts at 8:45 every day and doesn't take these just marathon comfort breaks, they could be done. I don't want to say by the end of the year, because they still have so much of their case left, but it's going to be, I mean, she's just going to embarrass Glanville in terms of her trial management skills and things like that. But in terms of like whether things are going to be totally different in terms of like rulings and stuff, I'm not sure. That remains to be seen. But remember, the next big date is July 30th. That's when she's going to be deciding motions or hearing the motions that are all supposed to be filed by the 23rd. So I don't know. I kind of think that we won't hear more about the outfit thing, but okay. So here's and this is important for Steele to do, because he understands how problematic the fact that Krause didn't find a problem with the ex parte. It, like, legally, it's a problematic. It's a problem for him moving forward to try to make these arguments that he's making, like I was saying a few minutes earlier, when another judge has actually found that ex parte was fine. So his new filing today, and this is via Thugger Daily on Twitter, is it's a motion to challenge factual findings, not result. Of course, he doesn't want Glanville back on the case, but he's challenging the findings of the Honorable Judge Krause's order dated July 15th, 2024, granting the motions to recuse Judge Glanville. So yeah, this is an important thing for him to do as an advocate and to keep advancing his arguments, because he needs to get her to throw out that, oh, this ex parte actually wasn't that bad, blah, 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 and rule that it was. So here. And then, okay, Joseph has another one. This is Joseph from Atlanta Journal-Constitution. He has motion to invalidate and strike all proceedings that occurred in the above referenced case on or after the initial motion to recuse Judge Glanville was filed on June 12th. And from my understanding, just from talking to the attorneys, is that Georgia case law is pretty clear that when a judge is recused, it's everything between the recusal motion and the recusal is like invalid. So my understanding is this should be pretty clearly granted, but who really knows? It's always open to interpretation, but anything after June 12th would basically be all of Woody's testimony. So that's kind of a few days of testimony for sure. But I don't know how you would really like unwind that too. But I think they're kind of taking this step by step, and that, you know, if she ends up doing that, that kind of gives them more grounds for a mistrial if they want one, you know. But we'll see here. We're going back to the finding, challenging the factual findings. This is Steele's motion. And these are the findings that they want to challenge. When Judge Krause wrote that, quote, divorce from its hyperbole, Mr. Williams' motion in supplement also seek to recuse Judge Glanville because of his involvement in the ex parte meeting, which Mr. Williams also alleges was improper. There is nothing. He doesn't like the word that they called it hyperbole. There is nothing hyperbolic in Mr. Williams' motion to recuse an affidavit. Steele's pissed, and stands by all law and facts therein. And then the next one is when it's when Judge Krause says that she, quote, agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. And yeah, so this is Steele trying to get Judge Whitaker to issue an order backtracking that on Judge Krause. I think that's unlikely, but who knows? Maybe she will. But I think she's going to be really reluctant to revisit a ruling like that, you know. But we'll see. He needs to. He's got to make it. Like I was saying, having those rulings in effect. Despite the hyperbole one is kind of more just he got his feelings hurt. But the ruling about the ex parte wasn't that big of a deal is like legally problematic for him. So I gotta sign off in a couple minutes, guys. I'm actually, if you guys are on your TV or go to Live Now from Fox, I'm gonna go on there at 3:30 and give a YSL trial update to everybody. So I'll have to get off there. But again, we have some new motions filed. It's Young Thug's lawyer Brian Steele challenging the two fact findings. Well, hyperbole is more of just an opinion or an adjective that Judge Krause used, but he's trying to get the new Judge Whitaker to go back on a couple of findings in Judge Krause's order, mainly about the ex parte meeting. But kind of the big news is today is that the judge is clearly planning to move forward. I mean, she was talking about scheduling and, I'm going to obey the days off for the jury. And she said, if we can't get the jury back this week, maybe, or, the week after July 30th, maybe we'll get them back the week after that. She was talking about not wasting time, getting things done quick. So, because, I was just kind of wondering, like, how wouldn't a new judge want to start over? But then, like I was saying, I was looking through things, and California has a pretty established policy for when a judge, if a judge passes or something during a trial, there's a procedure for it going to another judge. So it seems like right now, Judge Whitaker is just kind of approaching her taking over the case in that manner. But she still has not decided the motions for mistrial that I'm sure are coming. We've got the motion for bail / mistrial from Carrington Matthews. It's really just more of a bail motion. It doesn't really get into a mistrial argument too much, but the defense has till July 23rd to file their motions, and then prosecutors are supposed to respond on July 30th, and then July 26th. The end of July 26th is when prosecutors respond, and then there is a hearing on July 30th. And it sounds like we don't know if it's going to be one day. It could be an all-day thing, and knowing how this trial goes, there's going to be so many motions, but she's going to put Judge Glanville to shame in terms of her trial management stuff. I mean, she's going to start at 8:45, and I would bet it'll start about 8:45. I think she would probably kind of just start that time anyway. She seems like the type, but also in a case like this, she's going to make a point probably of starting on time. I guess she started a couple minutes early today, but and then they could go all week, and she wants to start at 8:45 all the time. So somebody asked if Woody's taking the stand again, and that remains to be seen. if she doesn't declare a mistrial and she doesn't start over, he is going to be back on the stand eventually, because she could rewind his testimony to the very beginning, like tell the jury, just forget everything you heard from Woody, like they haven't already. I mean, the way all the time lapses in this and everything. But unless she declares a mistrial and then they start over, it still remains to be seen. But just the kind of the attitude she was taking today and stuff, she is going to do what she can to not declare a mistrial and to keep it going forward. And remember, that might not necessarily be a bad thing for the defense, because the defense is thinking that they're winning this. And, and so, I mean, and it's things are going to change a lot just in terms of the flow of the schedule, which in some ways might not completely benefit them, because the prosecutors, one big problem for them is just all these big gaps. I mean, their case sucks already, but when they have like 3-day gaps between witnesses, it takes them like 2 weeks to get through one witness. It doesn't help their case. And it's really more of a benefit to the defense. But I don't think it's like a bad thing for the defense that things are now actually going to starting on time. So anyway, I've got to run. Like I said, I'm going to go on live now from Fox, but I'll upload later. And thank you guys all. I see the love on there, the follows and everything. I'll definitely do an update like next Tuesday when the motions are filed. I'll go through everything. But there's so many filings. Like I recommend following Thugger Daily on Twitter, of course, and Joseph from Atlanta Journal-Constitution. He's right there at the courthouse, so he posts the filings too. I've kind of given up on that. I mean, I'm more focusing on YouTube and TikTok and everything. So thank you guys so much for all the love. I wish I could stay on a little longer, but I got to get on there. So thank you guys. See you guys later. So much. See ya.